So let's begin with question 1 here. In Canadian society, which one of the following is not a goal of the law? Now, if you look at D, provide a way to resolve disputes peacefully, I think that's a pretty important goal that the legal system has. We don't want people fighting. We don't want violence. We want a peaceful, accepted way to resolve disputes, which are inevitable. Anyone else have any other guesses? Right. So Christian and Matthew are correct. Protecting the interests of the majority is not really a goal of the law. The majority in our system votes and usually carries the day. Protecting the interests of the minority is a goal of the law, minority rights. But majority rights are usually protected by the majority themselves. So the answer as to which one is not a goal, answer to number 1 is C. Number 2 is kind of a weird question. Procedural law covers the procedures and mechanisms for enforcing the rights and duties of individuals. Which one of the following is not a right or duty governed by procedural law? Steven says it's D. Yeah, it is an interesting question, and in my opinion, it's a poorly phrased question. Once again, this is an actual exam question, so something you have to be psychologically prepared for. Stephen went off the board and said V, but then said B. So I think the, yeah, all of them. The answer here is D, obeying laws. It's kind of the oddest one, but it is the correct one. Because obeying laws is not a procedural duty. It's a positive obligation, whereas freedom of certainly criminal prosecution is part of procedural law. But even freedom of speech and mobility rights can be grouped under that category in certain circumstances. So the best answer, even on this question, in my opinion, is not a good one, is D. On to number 3. Which one of the following is not a recognized means of alternative dispute resolution? Right. The answer to number 3 is A. Litigation is not an alternative. It's certainly a method of resolving disputes, but it is the standard go to court, fight a trial type of dispute resolution, whereas the other 3 are alternative to litigation. So the answer to number 3 is A. Number 4, which one of the following statements is not correct? Matthew and Benjamin are right. Tort law is not intended to punish. Tort law, contract law, all civil law is meant to compensate the injured party. Criminal law is the one that punishes the wrongdoer. So number 4, the correct answer there is B. On to the next page. Trespass to land is an intentional tort. How many do you have? Section 1 is out of 40, so you have to get 20 to pass the law section. Number 5, trespass to land, right, 50%, is an intentional tort. Which one of the following would not be considered a trespass to land? Yes, correct. The answer is A, where you have a right of way. It's not a trespass because it is a legal right to travel over someone else's property, usually to get to your own, but not necessarily. So the answer to 5 is A. Number 6, which one of the following is an example of an intentional tort? And that is assault and battery, A. The other 3 are not intentional, or usually negligence, product liability, and professional liability, usually through not intending to do something wrong, but doing it anyway. Number 7, in a negligence, should say negligence, not negligent, action, which one of the following will the court not consider? And why is D the correct answer? Okay, so the first 3 apply, but still, what about D is wrong? No facts, but the rule of res ipsa loquitur, which in Latin means the thing speaks for itself, shifts the burden of proof to the defendant when the plaintiff shows a very obvious set of facts. So would have to be painfully obvious, and it is a rare type of doctrine. It doesn't apply very often, but it shifts the burden of proof to the defendant, not the plaintiff. Number 8, which goes over 2 pages, in determining whether a breach of a duty of care has occurred, the court will compare the required standard of care. Right. Exactly, Matthew. Just like the brick example. The court will compare the required standard of care to that displayed by the defendant. Which one of the following would be the least relevant consideration that might be used in a court in determining the standard required? So we'll take a look at the first 3, and then we'll look at number 4. Yes, the quantum or size of the fee is irrelevant to determining whether there's liability in a negligence action. Number 9, in a tort of negligence, the plaintiff, in addition to proving there was a duty of care owed to the defendant, or by the defendant, and this duty of care was breached, must also prove that the action of the defendant caused harm to the plaintiff. The thin skull rule is which? That's right. The answer is A. It doesn't matter how vulnerable the plaintiff is to the loss or to the damage or to the injury. If there was a duty of care, if the standard of care was breached, and if harm was caused to the plaintiff, doesn't matter that the plaintiff was particularly sensitive, the defendant is responsible for the damages anyway. Number 10, valenti non fit injuria is sometimes used as a defense in a tort action. Which of the following best describes this doctrine? You guys are right off the mark there. That's good. Yes, B is correct. Valenti and voluntary sound kind of the same, so that could be a tip-off as well. 11, Donahue versus Stevenson was a landmark case in both product liability and negligence. Which one of the following statements is not correct? And why is D not correct, Stephen? Right. So when they ask you for which one is not correct, and once again, how many? You're unlikely to see any. So I would recommend that you not bother learning the cases. If a case is relevant, they'll tell you what it stands for. The way OSET has decided to do their exams now is a little bit different than in the past, when they looked at cases more frequent. It was a bigger part of the course, so it's not really big. Don't worry about it, or don't worry about learning what the cases stand for. They'll tell you if you need to know. So getting back to my earlier point, as I said in our first review, when they ask for which one is not correct and you see a word like all or never or always, that's usually the tip-off that that's what you're looking for. Number 12, that case is no longer on the course at all, so you don't have to worry about it. 13, a professional in dealing with a client is bound by contractual obligations, but has other responsibilities. Which of the following legal responsibilities is the least important for a professional to be aware of? Matthew says it's C. Wei-Hong agrees, and that is the correct answer. The possibility of being vicariously liable pales in comparison to the other three. Vicarious liability, of course, is when one person is held responsible for the wrongdoing of another, which leads us nicely into number 14. Vicarious liability occurs when a person is held responsible for the tort of another, even though the person being held responsible may not have done anything wrong. Which one of the following statements dealing with professional employees is not correct? Stephen says C. And Matthew agrees, and that is right. And why is the answer C? Right. Well, it doesn't say always, it says never. All right. And it does say always as well. Never and always. You got the double play there, right? So once again, this rule of mine, while not foolproof, not 100% reliable, is pretty reliable. Number 15, most projects involve some risk. Which one of the following statements with respect to risk allocation is incorrect? So these are the first two. Once again, we'll go back to the first two. Which one is incorrect? Matthew says it's B. And why is the answer B, Matthew? All. Right. Totally and all. There you go. Another example. 16, the essential elements required to make a contract binding are which? That's right. The answer is A, mutual agreement, capacity, consideration, legal subject matter, intention to be bound, enforceable form. D is close, but no cigar. The answer to 16 is indeed A. 17, which one of the following contracts does not legally have to be in writing? Stephen and Matthew say C. Which one does not have to legally be in writing? And the answer here is D. A, B, and C, according to the statute of frauds, do have to be in writing. But there's nothing special about contracts respecting investments, even though it would be extremely unusual for that to be a verbal contract. It's still, there's no legal requirement whereas the other three do have to be in writing to be valid. Number 18, in a disagreement over the interpretation of a contract, the courts will give consideration to various aspects of that contract. Parole evidence rule prevents the consideration by the courts of which of the following? And the answer here, let me just see. Christian says it's D, and Christian's correct. What the parties intended the contract to mean, strange as it may sound, is not something the courts consider. Express terms they obviously look at because they're right there in the contract. Implied terms as well, because implied terms are those that really have to be there for the contract to make sense. And the intent of the contract as a whole, as it is written, is the main rule of contractual interpretation. But what the parties intended it subjectively to mean, courts don't look at. And the reason is they want the intention to be clear from the written word. Right? If you want to agree to something in a written contract, put it in there. Okay? The intention otherwise is not relevant. So the answer to 18 is actually D. On to 19. A contract may be discharged by which? You're all off the mark quickly. Performance, agreement, and frustration is correct. The answer to 19 is B. And number 20, the last one in this little section. A business which suffers a loss as a result of a breach of contract is expected by the courts to do what? Matthew and Stephen say B, and that's right. And what does mitigation mean? All right, to reduce the severity, to lessen the loss, to otherwise reduce damage. Well, you guys certainly made short work of those 20 questions. In the other section, it took us at least 15 minutes more to get through this. So I guess well done. How many questions do you have on the final? It's 40 questions on the final. So you're probably going to see about, you're probably going to see one or two cases. So that'll take up 5 to 10 questions, and the other 30 to 35 will be just these kinds of questions. Okay. So expect to see, let's say 30 to 35. I would say 35 of the standalone multiple choice. No, it's 40 for the law, 30 for the ethics, and 30 for professional practice, total of 100. It's 100 questions. I'm giving you the answers, Aaron. This is what the answer is. This is what we're doing right now. Giving you the answers. Number 1. Well, I mean, you have the recording, so you can go back and listen if you want. Ethics. Number 1. Under what circumstance? Yes, that was the law. Under what circumstance is it acceptable for a technology professional to disclose confidential information? All right, that's a pretty easy one. When the public is endangered, confidentiality takes a back seat. Number 2, select the statement that least represents a type of ethics case. We have a C and an A. And the answer to number 2 is C. Not having professional liability insurance is, of course, foolish, and it is a professional practice issue, but it's not an ethics issue. So here the answer is C. Number 3, which one of the following statements is not correct? Right, an action that is morally or ethically wrong is not necessarily legally wrong. Right? So legal, ethical, moral often go together, but they're not necessarily the same. There's a significant degree of overlap, but they're not identical. Number 4, James, a chemical engineering technologist, is working with a process which will discharge a small amount of compound into the sanitary sewer. Compound X is not listed as a restricted product for discharge to the sewer. What is the issue that James must deal with first? And this is option A, and these are the other 3. Sure, we'll show you the question again. Is it a confidentiality issue? Is it a factual issue, a conceptual issue, or a legal issue? And the answer is what compound X is, but we don't know whether, because it hasn't been prohibited, then you have to figure out whether it is dangerous or not. So that is more of a conceptual issue than any other kind of issue. Number 5, a technology professional has accepted an offer of employment. Which statement best reflects their obligations? So we have somebody answering A, somebody answering C. Anyone else want to weigh in? Yes, A is correct. I mean, they get progressively worse and wronger as you go down, more wrong, excuse me, as you go down from A to D. But the ethical obligation of the professional is best described by A. Number 6, moonlighting, which you all know what that means now, or do you? I think I explained that in the first review. Moonlighting generally has a negative connotation with respect to refresher. Yes, so moonlighting is what you young people call a side hustle these days, a job that is supplementary to your regular full-time job, or business that's supplementary to your regular full-time job. So moonlighting generally has a negative connotation with respect to one's full-time employer. Which one of the following might be acceptable? Yes, and the reason that's acceptable is why? Because of the consent, of course. You've disclosed it to your employer. They know they're okay with it. They're not worried about conflicts of interest or anything else. So you're free to go about your side hustle as you please. The answer to 6 is C, providing consulting services to outside organizations with the consent of your employer as a service to your corporate customers. Number 7, technology professionals are bound by the code of ethics to maintain their competence and to engage only in activities they are competent. Which one of the following would be the least desirable method of maintaining competence? Yes, you know, you can tell it's an old exam because of the old World Wide Web. Obviously, like going online to keep current is probably not the best way. It's the least focused of them all. Wikipedia isn't always the best place. I agree with you there. Although it does come in handy sometimes. Number 8, as a certified member of OSET, when are you least likely to encounter intellectual property and copyright issues in the workplace? Yes, I think I had this on one of our tests. If I'm not mistaken, it's D, working with standard engineering equations doesn't involve any intellectual property issues. Number 9, the cost-benefit approach to the regulation of environmental pollution has a goal which is stated as? Which is kind of the definition of the cost-benefit approach. Yes, Stephen Long is correct. The answer is A. In other words, the cost-benefit approach basically says that you get it to the minimum required level of cleanliness, and then you really have to look very carefully as to whether any resources on top of that are better used anywhere else in the organization as opposed to any kind of environmental, or can be put to better use somewhere other than environmental. Number 10, which one of the following is least relevant to risk assessment? Aaron says the answer is B. Who agrees? So it's tough. I mean, I think it's pretty easy to eliminate A and D as least relevant. And B and C do sound awfully similar. But staying within budget and looking at cost as the main factor are not the same. The least relevant to risk assessment is focusing on cost at the expense of other considerations. So the best choice for cost is not what you're supposed to be going towards. You're supposed to be looking at all factors, cost or budgeting being only one of them. Staying within budget and looking for the best choice for cost are not the same. So the correct answer, number 10, is B. All right, well, we still are going very quickly through these. Which one of the following statements about a sole proprietorship is not correct? Okay, everybody knows that one. The answer is A. Number 2, which one of the following statements best defines a partnership? Everybody knows this one too. It's B. Number 3, which one of the following statements is not correct? So let me show you these. And then show you the last one. Then go back to the first 3. What's the answer to 3? The answer is C. A province cannot regulate a federal corporation. Only the federal government can regulate those. Number 4, a corporation may raise funds through the issue of debt securities. Which one of the following is not a debt security? That's right. B, preferred shares. Shares are equity securities. They're not debt. Any kind of shares are equity. Number 5, which one of the following is not a typical goal of a professional organization? Right, limiting the number of licensed practitioners, at least not, not officially anyway. Number 6, professional liability insurance is intended to provide protection to a number of parties. Which one of the following would not receive protection? D is not the correct answer here. The public or third parties, if they're injured, obviously, do receive protection and liability insurance, professional liability insurance. Does anyone have any other answers? Going to take the L on this one. The answer is B, the employer of the professional. The employer is not usually covered by individual professional liability insurance. The professional is, the employer is not. They generally have their own policies. Number 7, the OSET certified member ID stamp may not be used on which of the following? We have a question and a question from Wei Hong. But if they are injured, won't they become first party? Well, if you're the employer, you're vicariously responsible for your employee. Suing your own employee, assuming the employer is not a corporation, would be difficult, I think. Number 7, the answer, as Stephen Lung says, is B, because documents that require an engineering stamp need to have an engineering stamp, not an OSET stamp. Right? And number 8, the OSET Act and the revised Act of 98 are referred to as what? The answer to number 8 is A, right to title legislation. Will the final ask about dates? Sometimes they ask dates, yeah. Yeah, I cannot guarantee you. Unlike cases, which I'm pretty confident you don't need to know, the dates may need to know. So the reason the OSET Act and the revised one are called right to title legislation is because the OSET Act allows the creation of an organization that gives out titles. Just because you don't have an OSET designation doesn't mean you can't work in the field. It's just that you can't hold yourself out as a certified technician or a certified engineering technologist, right? Only OSET members can do that. But it doesn't mean that if you're not an OSET member that you can't do that kind of job, especially if you're working for an employer as an employee. It gives you the right to title. Professional legislation, scope of practice legislation, says that in order to do this kind of job, you have to be a member of this organization. If you want to be a doctor, medical doctor, you have to be part of the Ontario College of Physicians and Surgeons. If you want to be a lawyer, you have to be a member of the Law Society of Ontario, and there's a whole bunch of professions that work that way. OSET doesn't work that way. That's why the answer to number 8 is A. Number 9, which of the following is not a certified member of OSET? And the answer to number 9 is C. A graduate technologist is not yet a certified member of OSET. Certified engineering technologist, a CET. Right, so the applied science technologist title is no longer given out. But if you got it when it was given out, you're still a certified member of OSET. You can continue using that title, but only the certified technician and the CTEC and the CET, the certified engineering technologists, are given out these days. So the answer to 9 is C. Number 10, OSET's complaints committee may, on completion of its investigation, take certain actions. Which one of the following is not within that committee's power? Stephen says it's A. Any other comments, answers, agreement, disagreement? Okay, Matthew agrees, and that's correct. And why is A the correct answer? Right. You go to the discipline committee to suspend an individual's membership. It isn't done through the complaints committee. It's referred to the discipline committee, and they figure it out after a hearing. All right, so that's that. Let's see. Let's go on to the next little exam blurb I have. Okay, a few more. Which of the following is a characteristic of a sole proprietorship? Number 1. Yes, the answer there is B. Number 2, which of the following statements is true of a partnership? And the answer here is D, unlimited liability. So that the liability of each partner for the debts of the partnership is indeed unlimited. Number 3, which of the following is an advantage of corporations over other business organizations? The answer here to number 3 is C, the continuity of management and organization. Employees, managers, shareholders come and go. Corporation continues. The reason A might appeal to you is because you think it's limited liability of each shareholder for the debts of the corporation, but that's not what it says. There's no limited there. It says liability of each shareholder for the debts of the corporation. Of course, shareholders are not liable for the debts of the corporation. That's why you incorporate in the first place. So the correct answer, number 3, is C. Number 4, preferred shares of a corporation have 2 special rights. Which are they? And they are dividend rights and wind-up rights. The preferred shares don't have full voting rights. Number 5, which of the following is not a typical goal? Yeah, it's just same as last one, different exam, same question. Number 6, the purpose of individual professional liability insurance is not to See, same question, just phrased different. Answer number 6 is C. Number 7, the OSEP member ID stamp is used for the purpose of. Correct answer to 7 is A, identifying the work for which the member is responsible. Number 8, which Ontario law governs an employee's hours of work? And that is the Employment Standards Act. Number 9, the certified member category does not include graduate technologists. So, just to show you, the questions on different exams can often be kind of the same. They just phrase them in a different way and the answers are a little bit different. Doesn't mean that'll be true on your exam, but it does happen. Matthew asked, are there only so many questions they can ask? Well, you'd be surprised. They have a really big pool of questions that they can ask, and they're randomly assigned to you as you take the exam. So you're going to get some repetition. I'm pretty sure that some of the questions that we've gone through in the review, both today and the previous class, you're going to see on your exam. But that's going to be a small minority, right? Somebody told me in the previous semester that out of 100 questions, he only got, I can't remember what he said, 6 or 7 that were the old ones. Now, 6 or 7 questions is still pretty good. If you know the answers to those and you can bang those out, save time for the others, save energy for the others, you can really improve your score. But it's still 6 or 7 out of 100 is not a lot. There are a lot of questions that they have in their pool. And number 10, the Complaints Committee shall not consider a complaint regarding the conduct or action of a member of the association made by. We have an A and a D response. Anybody else? The correct answer is A. An employer alleging refusal to stamp the work the member has not completed or supervised is not a violation of your professional obligations. So if you don't complete work and you didn't supervise, you're not supposed to stamp it. Doing so is a violation. Not doing so is correct. So the answer to number 10 is A. All right, so that's kind of what I got for today.